Caller, criminal defense attorney Carolyn Polisi, defense attorney and former federal prosecutor Shan Wu. Ryan Young is also live for us in Brunswick. Shan, though, I want to begin with you. As a former prosecutor, as you're watching the way that this unfolded, yes, it's what you want a prosecutor to do in a rebuttal, right? Rebut what they have heard from the defense. But what else stood out to you in the way that Lisa Dunikoski laid this out?
I thought she did a good job. She really tried to give the jury the high points they should focus on. And to me, what I came away with was this idea that the knowledge that the defendants had simply doesn't add up to give them a basis for this alleged citizen's arrest defense. I thought she did a very good job of using the video, going through what can be a complex timeline to show that they really had no reasonable basis or even to know at all the crime had been committed, and that implicitly focuses it back really on the racial animus, that as we heard in that recording, the crime is a black guy running down the street. So I thought she did a very good job of that, as well as tying in how the non-shooters are the party to the crime under their theory.
Yeah, her line there, what's your emergency? There's a black man running down the street, her paraphrase of the 911 call. To your point, Shan, she made a clear distinction there because there'd been some portrayal in the defense, perhaps based on McMichael's experience in the Coast Guard, that he was somehow a qualified law enforcement officer or someone able to make law enforcement judgments. She referred to the testimony of someone she identified as an actual law enforcement officer with a badge who said that based on what was known there would have been no arrest by someone in uniform. So Carolyn, then that leaves other defense strategies, of course, which is going after the victim to some degree. And I want to play one response that the prosecutor used to that defense argument. Get your reaction. Have a listen.
Laura Ho got up here and she gave you Criminal Defense 101. Usually Criminal Defense 101 is no crime actually took place. Well, crime's on video. My client didn't commit the crime. Well, yeah, your clients are on the video committing the crime. Criminal Defense 101, Step 3. It's the victim's fault. Standard stuff.
Do you agree, Carolyn Polisi, that that's where, in effect, the defense stands at this point, that she characterized that powerfully or impactfully, rather, to the jury?
Well, absolutely, Jim. I think she was rightfully so calling out the defense attorney's arguments yesterday, some of which were really out of line and inflammatory, specifically with respect to the long, dirty toenails commentary. Yeah. That clearly was a dog whistle to any racist jurors sitting on that jury panel. The defense attorney did what she thought she had to do, and the prosecutor there was really calling her out for that. You know, I think the real issue here that Shan aptly noted is this citizens arrest law, and you saw them, the defense attorneys, actually object in the rebuttal by the prosecutor earlier today, which is a pretty drastic move, moving for a mistrial, saying that the prosecutor had actually misstated the law. They're actually arguing over the temporal boundaries of when a citizen's arrest can be implemented by a citizen and whether that the crime and or felony had to be committed within the direct presence or sometime thereafter. Really, that's all the defense has their hat to hang on in this trial. And if they don't get the benefit of the citizen's arrest law, their whole case goes down the drain, because then they don't get to argue self-defense. So I think that the defense homed in on really the key points of this case, but I think the prosecutor did a great job rebutting it.
In terms of that self-defense claim, she made very clear from the beginning here, Shan, you can't claim self-defense if you're the one who started it. Did she make that point effectively today?
I think she did. I think she's done a really good job with using the totality of these circumstances, because sometimes you want to really break it down moment by moment to show that a split-second decision actually was something much longer. And that's what the defense wants to make it look like, is that this is a split-second decision, that Travis is in fear for his life. And what she did a good job of doing was showing the totality of what led up to that really undermines that idea. You know, and to Jim's point, about the idea of portraying him as a law enforcement background training with the Coast Guard. I call that the best of both worlds defense, which is on the one hand, they want the vigilante to be portrayed as doing things by the book. He is trying to de-escalate. But at the same time, they want to say, oh, he's really a scared, frightened citizen in fear for his life the way any of you might be afraid for it. And so they're trying to have the best of both worlds there. And I think the prosecutor, did a good job of really undermining that point. And I think also to Carolyn's point about the portrayal of the victim, that very really racist remark that was made. I mean, I think one interesting comparison to the Rittenhouse trial is what a difference it makes when you can call victims victims.
Yeah. Well, and another comparison, by the way, very different cases, is the idea that in each case the defendant said it was their weapon that they brought that they were fearful that the other person was going to take away to justify the threat to themselves, which I do want to get your sense of that legally, but we do have Ryan Young there outside the courthouse now. He's been covering this trial since the beginning. And Ryan, one point I think worth noting to viewers is that some of the legal drama here took place with the jury outside of the courtroom.
Yeah, absolutely. You think about everything that's played on outside the court so far. You think about all the statements that Kevin Goff has made over the last 2 weeks or so and has really sort of inflamed the feelings in this community. You think about all the black pastors who arrived after saying he didn't want more black pastors. And you think about the fact that there have been protests in the street directly responding to what the lawyers have been saying in court. And one thing I wanted to pick up on, Jim, that you brought up is the pictures that were shown in court. You could really feel the change every time those pictures were shown. And when you think about parents sitting in a court and having to see the dead body of Ahmaud Arbery sitting there next to his picture of when he was alive, it was something that we couldn't show because it was quite graphic, but it really, every time they've shown those pictures, the court watchers have told us it has changed the tone inside the court. I mean, there's been conversations about one juror who was apparently falling asleep at certain times. We know every time the video is shown, we know every time those pictures are shown, nobody is not paying attention to what it is. So you feel that when you get it all together. And that picture really stuck with me as they showed it in closing and she put it up on that screen. It really took your breath away to think about that's how she was ending this today.
And that's to your point, Ryan, that's the image that she wanted to leave with the jury. The ultimate outcome of this situation is the death of a young man in a very graphic way. One of the points, and Shan, you touched on this a little bit, but she also really drilled down on William Roddy Bryant being a party to the crime, because we know that his attorneys were hoping that maybe that would not be the case. And she set this up. She's the analogy of a bank robbery. That if you're driving the car, if you're on lookout, you are still just as guilty as the person who pulls the trigger if someone in your party went in there and shot the security guard at the bank. Do you think that's something that, as a jury, they are going to follow that? Yes, it's the law in the state of Georgia. Was that the right analogy for her to show why all three men, when it comes to the law in Georgia, would be equally guilty?
I think that's exactly the analogy she had to make. Bank robbery is a good one because here, his defense, Roddy Bryant's defense, is really that he is really just the guy filming this on his camera. He's got nothing to do with it. I thought she did a very good job of using the statement he made, y'all got him, and him jumping into the phrase. So I think for most people, common sense, they understand the idea of driving a lookout vehicle. That's how you can still be involved in a felony murder that occurs inside the bank. So I think that was a good analogy. And I think, it's a tough call. There's been questions, I've questioned, whether she made a bad strategic choice not focusing on race more. You have to play to what you know with your jury, but you also have to trust the jury. And she's trusting the jury here that they're going to follow the law and they're going to use their common sense. And that's what she's really asking them to do.
No question. And repeating that it's about the facts of the case, not about point of view or goodness or badness of the defendants themselves involved. Carolyn Polisi, I do have a question because, again, very different cases, but in both the Rittenhouse case and this one, you have the defendant justifying self-defense by saying, I had my weapon and I was fearful that the other person might take that weapon and turn it on me. How does the law see that, particularly when a person brings the weapon to the fight, as it were?
Exactly. And the prosecutor sort of made that point in her closing, not necessarily in her rebuttal, but she said, they were the ones that brought the gun to the knife fight, so to speak. Well, in this instance, they brought a gun to Arbery's jog. So there is, in the law, there is this idea of proportionality, and the prosecutor made that clear that when you have a self-defense claim, you can only use a proportionate amount of defense to make yourself sort of safe in that regard. And so what is a proportionate amount of defense when somebody is unarmed? She noted over and over again, the bagginess of Arbery's pants, that it was clear that he wasn't armed, that in the defendant's post-arrest statements, they did not make it clear that they thought necessarily that he was armed. Of course, now, after having the benefit of hindsight, they have clarified their testimony, and on the stand, of course, they're saying, oh, they feared for their life, but really, the proportionality element wasn't there. And then, Jim, they don't even get the benefit of the self-defense defense if, in fact, they weren't committing a lawful and legitimate citizen's arrest, which is why that's such an important element.
I believe the judge has brought in the jury back into the courtroom. Actually, we're waiting. He's asked for them to come back in. Erica, back to you just as we wait.
I was going to say exactly as we're waiting for them to be brought back in. I'm just looking back at my notes in terms of things that I wrote down as we're watching all of this. And to Carolyn's point, all this talk about this has to be about the evidence. This has to be about the facts. We know that ultimately that is what the jury is supposed to look at, will be looking at. Shan, as they're given those instructions, that is all about the facts. Remind us, how important are the closing arguments?
The closing arguments are really important because of two things. First, they're the last chance for the lawyers to make the point to the jury. It's what you leave them with. And secondly, it's because it's the first time that the lawyers really get to argue. An opening statement is really supposed to be a preview of what you're going to show them. But in the closing, you're able to take the evidence that's been brought in, add your passion, add your narrative to it. And that's what's really important. That's why they call it a closing argument. So here, big advantage that she got a fresh jury. I was criticizing her yesterday for wanting to push through at the end of the day with 2 hours more of argument, but she got them fresh this morning. She's the last voice they'll hear, and then they hear the law. So that's a good setup for her.
That's a good point. You want them to be paying attention as you go through your final argument. I believe, if I heard the judge correctly, that they're standing here because the jury is being brought back in. Of course, you don't see the jury in this shot. Let's listen in.